So I head up the Manx Industrial Relations Service, and part of the remit is to provide employment best practice to employers and employees and workers. And as part of that, because these changes are so wide ranging and will affect a lot of people on the Isle of Man, we've been doing some presentations for the general public. They've been well received. There's been a lot of questions following them, so we've been trying to answer those as best we can to make sure that everyone's prepared for the changes that are going to take effect from the 1st of April.
Okay, so can you take us through then some of these changes that are coming into force? What do employers need to be aware of?
So I think first and foremost is the changes to written statements. So these are effectively the minimum requirements under the Employment Act, whereby an employer has to provide a written statement to cover the minimum standards by law to workers. Now, this was previously within 4 weeks from the start of employment, but now it's becoming a day one right. So employers will have to provide this written statement to all workers on or before the first date of their employment. And there was a change last April as well, whereby it was changed from just employees to workers. So this is going to affect all employers on the island, really, and it's just to make them aware of this change and so that they can get the preparations ready.
So written statements, that's sort of outlining the terms and conditions, the contractual obligations of the employee as per the contract. Is that right? That they're being hired on?
Yeah, under the Act, it's called a written statement, and it's the minimum requirements that an employer has to outline. Now, these can be included in a contract of employment that can be wider than a written statement, but under the Act, there's just some minimum requirements that an employer has to outline.
Okay, so when we were talking about it being 4 weeks before, what sort of complications could that throw up in the past, and why will this being on day one, what benefits will that bring?
So previously it was in 4 weeks of employment, so employment could begin and then the employer could draft up the relevant written statement. Because it's on or before day one, an employer will have to get this ready from the first date of the employment. And in terms of what our office is providing advice on, we are certainly saying, have this drafted up as part of the job offer, so then it is ready to go on day one. Or as part of an induction, that this written statement is provided to the worker as part of the induction process, and then the employer can be satisfied that they're producing this.
And something we've been talking about a lot, and that has got a lot of attention, is time off around, for employees that want to go and have children and maternity leave, antenatal appointments. Tell us what's happening there.
So the antenatal appointments, this is a new right that's coming into effect for employees. Now, a mother-to-be already has a right for paid time off to attend antenatal appointments. And this is for partners to be able to have a right for time off to attend those appointments as well. Now, for partners, it's an unpaid right for time off. And partners is defined under the Employment Act. So there's certain categories that a partner will fall under. So, husband, wife, civil partner, someone in an enduring family relationship. What's worth noting is that our definition of partner is wider than the UK definition. So our definition of partner will also include relative and a woman's birth partner. So that's just something for employers who have different offices in different jurisdictions just to be aware of. But in terms of those appointments, it's under the new right, it'll be 2 appointments and each appointment up to 6.5 hours long. So it's not a general 13-hour right for time off or open-ended. It's very much restricted to what the right is going to be contained to. And they have to be made, the appointment has to be made on medical advice. So the employee also can't categorise an appointment as antenatal. It has to be an appointment that's made on medical advice. But for employers, they can ask for a signed declaration from their employee to say, the date and the time of the appointment, what their qualifying relationship is under the Act. And that just means what category of partner do they fall into. And, that the appointment is made on medical advice. So the employee is getting that comfort that why they're going to have this time off for.
Mm. Some developments as well in adoption appointments. Tell us what's happening there and how groundbreaking is that in terms of Manx sort of legislation currently?
Yeah, so currently we already have adoption leave. So that's where a child's already been placed with the parents to be. This one is very much a right for time off to attend adoption appointments, and it's before a child gets placed for adoption. So it's to attend all the appointments to make the arrangements for the adoption itself. And this is what I call a split right. So it depends on if an employee is adopting by themselves or jointly with their partner. If they're adopting by themselves, they're entitled to paid time off, and this is capped at 5 appointments, again, each for 6.5 hours long. If they're adopting jointly, then one partner is entitled to that paid time off, but the other partner is entitled to unpaid time off, and then it reduces down to 2 appointments, each for 6.5 hours long, but only on a joint adoption, only one partner can elect the paid time off and the other has the unpaid time off.
Right, okay. I mean, we see often, don't we, in TV programs, in movies of characters going through the adoption process, and you see how stressful it can be. So anecdotally, how much relief do you think this would bring for somebody going through that process?
I think it just brings certainty for those employees that they do have a right to be able to request that time off, to be able to make those preparations. It would be analogous to, antenatal appointments. They have time off to make the preparations for the baby, and this one is time off to make the preparations for the adoption.
And one thing we've particularly been hearing about is, well, for a number of years, a calls for shared parental leave. And within the DFE's press release a couple of weeks ago, they said later in the year, and we're hearing that they are moving in, and there's lots of secondary legislation to get on top of before that comes in. But is that something that's called for often, do you think?
I know it's not used that much in the UK, so I'm not quite sure what the uptake would be on the Isle of Man, but I don't know any further details on the shared parental leave aspect over here. But it's something just to, I think, employers to be aware of, that it might be on the horizon, definitely.
Yeah. We're talking now then about time off to care for dependents. Tell us about that and why this is coming into force.
So a similar right has been in the UK since, I think, 1999, and this is really a right for time off to deal with unexpected issues relating to a dependent. So these issues are also categorised under the Employment Act. So, it covers things like illness, injury, death of a dependent, unexpected disruption for the care of a dependent, and, an incident at an educational establishment. What's worth noting is that injury and illness also includes physical and mental injury and illness. So that's the types of issues that could arise to have this time off. Now, the time off, again, is unpaid time off. So it's really for employers to be clear and employees to be clear that this is a right for the leave, not for the paid leave. And what's interesting under this right is that the right is for reasonable time off, but there's no further guidance on what is reasonable. So it'll really be on a case-by-case basis. And for the employee to be able to get this right, to be afforded this right, they have to tell their employer the reason for the absence as soon as reasonably practical, and how long they expect to be off. And if they don't inform the employer of that, then they run the risk that they won't be allowed this time off right.
And on the flip side as well, there's a warning here. If the employer gets it wrong, tribunal can award compensation in these cases.
Yeah, as with all the new rights, they are statutory rights, so they are afforded to employees by law. So if an employer does fail to adhere to the statute, to the Employment Act, then they do run the risk of an employee making a complaint in the Employment and Equality Tribunal, who may award compensation for a breach of this.
And that's, I suppose, the important aspect of it, isn't it? It's that these aren't just nice-to-haves that we're talking about. These are, as you mentioned, statutory rights. So really important employees get on top of this.
Absolutely. And it's just making sure that their policies and procedures and line managers and all those dealing with employment and HR issues within the organisations are aware of these changes that are statutory rights to employees.
We'll move then to whistleblowing, and very technical area, I imagine, this, and something we often hear about up here at the station. But tell us what's happening here.
So whistleblowing it's a common term used for making a protected disclosure under the Employment Act. And the protected disclosure regime is already in place in the Isle of Man. There's just some changes that are being brought to it. Now, there's a lot of changes, but the main ones I think that are worth noting is that there's going to be an introduction of the public interest test. Now, what this means is that to ordinarily make a protected disclosure, there's no requirement for it to be in the public interest, and the UK already has this requirement in. The introduction of this means that an employee or a worker can't make a whistleblowing complaint or a protected disclosure for their own self-interest. It has to be for a wider cause for the public interest.
Okay.
There's no definition of what the public interest is.
I was going to say, so how is that worked out?
Yeah, so it'll really be on a case-by-case basis. And certainly in the UK, there's been some case law on that. But it'll really be for our tribunal to assess how they're going to interpret that.
I was going to ask, so where does the Industrial Relations Service step in whistleblowing cases, and how can you help out?
So I think for all of these, Manx Industrial Relations Service, we offer a free, impartial and confidential service for a wide range of service users. So employees, workers, employers, trade unions, advocates. And we advise on best practice, best employment practice. And we also get involved where complaints are made to the Employment Tribunal, and we can help conciliate those in terms of settling any complaints and helping with those disputes.
So as we've been talking, we've taken a whistle-stop tour through all the changes that we're talking about: written statements, antenatal appointments, adoption appointments, time off to care for dependents, and whistleblowing. Lots and lots to take in. For any employer that's perhaps listening across this who's thinking this is a lot to take in, and for any new employees as well, what's the best advice you can give right now?
I think just have a look what you already have in place. Make sure it's going to be in line with the new legislation, but also have a look at our website. We have a lot of information that you can access in terms of templates that you can use, guidance notes, checklists. But if in doubt, just get in touch with us. We are happy to help anybody. Pick up the phone, email us, and we're happy to help.
And it is ever evolving, this landscape of employment rights. And as we're hearing, again, later in the year, we're expecting more new rights to come in. How easy is it for you guys at the Industrial Relations Service to keep up on top of all this?
Well, we hear day in, day out all of the queries in terms of employment and HR issues. So it's very much our job to be alive of all of the updates. Mm-hmm. And so we'll be keeping a close eye on any further updates. And I'm aware of some consultations that have closed with the responses. So we are keeping abreast of those further updates, and we will be providing presentations and materials to help the general public on understanding any future changes as well. Prevention is better than cure. So get in touch with us if you have any questions as an employer, worker, employee, and we're happy to help.
Thank you for making it to the end of the Manx Radio Newscast. You are obviously someone with exquisite taste. May I politely suggest you might want to subscribe to this and a wide range of Manx Radio podcasts at your favourite podcast provider, so our best bits will magically appear on your smartphone. Thank you.